Exercise number 34. Start. Other person under this act, comma, shall, comma, save as otherwise provided in section 529A of the Companies Act, comma, 1956, comma, the recovery of debts due to banks and the Financial Institutions Act, comma, 1993, comma, the securitization and reconstruction of financial assets and the enforcement of security interest act, comma, 2002, and the insolvency and bankruptcy code, comma, 2016 be the first charge on the property of the assessee or the person, comma, as the case may be. Stop. Section 142A of the Customs Act was inserted by Act 8 of 2011 with effect from 8th April 2011. Stop. It does not apply to the present litigation. Stop. Section 142A of the Customs Act protects and ensures that the dues under the Customs Act do not, comma, in any way affect the rights of third parties under Section 529A of the Companies Act or rights of the parties as per provisions of the recovery of debts due to banks and the Financial Institutions Act, comma, 1993, comma, the securitization and reconstruction of financial assets and the enforcement of security interest act, comma, 2002 and the IBC. Stop. Read in this manner, comma, it is clear to us that the provision of section 142A of the Customs Act, comma, insofar as it protects the rights of overriding preferential creditors governed and covered by section 529A of the Companies Act, comma, is clarificatory and declaratory in nature, comma, and does not lay down a new dictum or confer any new right as far as the present case is concerned. Stop. Para. However, comma, the enactment of section 142A of the Customs Act does confer or create a first charge on the dues payable under the Customs Act, comma, notwithstanding provisions under any central act, comma, but not in cases covered under section 529A of the Companies Act and the IBC. Stop. Section 142A of the Customs Act, comma, post its enactment, comma, would would dilute the impact of Section 530 of the Companies Act, comma, which had restricted preferential treatment to government taxes due and payable limited to 12 months prior to the relevant date, comma, without preferential right for taxes that had become due and payable in the earlier period. Stop. In view of our reasoning, comma, we must hold that the decision of the Division Bench of the Calcutta High Court in Ditron, India Limited does not lay down the correct law. Stop.